covering as much as possible the common causes of action that you see in district court in Maryland. I will be also including some information that is particular to Baltimore City. That is where I'm personally am located among our statewide offices. But just remember, this is not legal advice, it's purely educate, just to raise your awareness about what are the possible cause of action and defenses that tenants may have. If you are interested in Maryland legal aid representation, you might by all means call our intake line at 410-951-7750, or you may also go online at mdlab.org for more information. By all means, you're free to type in your questions and we will get to them as best we can, but more likely we will also be addressing everything at the end of the presentation. So just to show in terms of what we'll be covering for this presentation, this is some of the most common things you may see in landlord-tenant is failure to pay rent, rent escrow, tenant holding over, and then at the end, we'll cover a checklist of things to keep aware of if you are about to go to court, as well as some helpful information about if you are looking into a property to rent, what are some things you may want to be aware of before you sign that lease. Okay, so without further ado, talking about failure to pay rent. So failure to pay rent is, in general, it is where a landlord-tenant, there's a relationship that exists, tenant hasn't paid rent, as well as any late fees that's due and owing, and the landlord wants to take the premises back because the tenant failed to pay. So for the landlord, this is an opportunity for the landlord to take back the premises. Landlords can get up to 5% of rent in terms of late fees, plus court costs of $30. If the landlord filed this case, let's say towards the end of the month, whereby the new trial date will come up sometime after the first of the month, and let's say new rent comes due, the landlord may also add that amount into the complaint. From what we know of the reopening process for the district court, courthouses or district court may start hearing failure to pay rent cases beginning in August 31st, so that'd be on Monday. And I believe in Baltimore City, they'll be starting hearings on Tuesday, September 1st. And many parties should have received their summons to go to court beginning last Monday. So if you feel as though you're in this particular situation, this may be coming up, please be on the watch out for the mail to see if a complaint has come out. Now, I'm first going to talk about more about the process leading up to an eviction, and then we're going to cover more about the tenant's defenses. So first, once a tenant gets a complaint, landlord files a failure to pay rent complaint, that's supposed to be transmitted over to the tenant. Tenant then, they go to court. The judge looks at the issue of whether or not there's rent due and owing. If the court finds in favor of the landlord, the tenant has 4 days to file an appeal. In that filing appeal, there may be a bond set so that if the tenant wants to commit or show proof that they are doing this in good faith, the court will set the amount in which the tenant must pay in order to stop an eviction based upon that judgment. Also, parties will either side have between 10 and 30 days in most situations to file a motion for a new hearing or to alter amend judgment. One of the most common things we see this is where a landlord takes tenant, gets a judgment, but then tenant belatedly realizes that landlord had no license to rent, and therefore they should not have gotten that judgment, in which case a motion may be an appropriate route. But because fail to pay rent is about getting paid that rent in lieu of maintaining possession, if the tenant is able to gather the amount of money that's owed to the landlord up until the moment of the eviction, we call it pay and stay, the tenant may be able to keep their property. Now, this judgment has occurred in most jurisdictions. If the landlord's gotten 3 prior judgments within the preceding 12 months, or in Baltimore City before prior judgments, the landlord can ask the court to remove this right of redemption from the tenant. So therefore, if this happens multiple occasions, the landlord could say, look, it's not about the money anymore. I just want you out of this property. And with the court's consent, that right may be taken away. So that's in terms of those intermediate steps here. Once a court has judgment, landlord files what's called a warrant of restitution with the court. This is the actual order from the court to the sheriff, directing the sheriff to conduct an eviction. So it's kind of like the second step. First judgment, then the warrant of restitution. The landlord has up until 60 days from the day of judgment to file this warrant. In Baltimore City, when it comes to actual notice of the eviction, once a warrant of restitution has been issued to the sheriff, notice is given to the parties, landlord can call the sheriff and schedule the eviction. In Baltimore City, at least 14 days before that eviction date and time, the landlord must give notice to the tenant that is about to occur. At least in Baltimore City, this is only for fair to pay rent cases. But first, it's 14 days supposed to be a letter is mailed out to the tenant, and then 7 days prior, there needs to be a posting on the property to give the tenant notice that an eviction is pending, which would be the last moment chance where the tenant can actually pay back the money to keep the property. If the tenant remains, then, or if no money has been paid, then the sheriff may conduct the eviction, and any property left within the premises is considered abandoned. So by all means, if a tenant is in a situation where there's no other defenses other than paying rent, then the tenant needs to consider, well, should I pay to stay, or should I just prepare to actually vacate the property? Now, there are some opportunity to delay, especially during the pandemic here. So if a tenant believes that an eviction would harm them or threaten them or any of their occupant, their life or health, safety, and that includes COVID-19, the tenant may present a motion to the court attached with a physician's certificate saying, hey, if an eviction occurs today or on a scheduled date, then it will threaten my life, health, and safety. The court has the power to stay that eviction up to 14 days. If a tenant is in that situation, the tenant should, we would advise is to go to the courthouse, the eviction prevention unit on the second floor, and at least in Baltimore City. I'm unsure how it is in other courthouses, but at least possibly even go to the self-help center in many district courthouses to prepare this motion. At least in Baltimore City, one other thing we know is that the sheriffs will inquire of tenants if anybody in the household has or been, directed to self-quarantine due to COVID-19 infection or exposure. The sheriffs will be wearing PPE, and they'll be asking those questions, because if a person does have COVID-19, then the sheriff may also decide to reschedule. Now, also, this is in Baltimore City, but from many other jurisdictions, if there is a dispute that occurs on the day of eviction, let's say the tenant paid, has receipts, but for whatever reason, the landlord still want to press on with it, the sheriff in their judgment may also direct both parties to go to the courthouse. In Baltimore City, that'd be the 130 docket immediately, so that the judge will settle the issue and determine whether or not to conduct an eviction. Okay. So when it comes to, at least in fair to pay rent, the most common defenses, number one would be that the tenant paid. They pay the rent late fees. If you pay, you get to stay, provided you still have that right. Maybe in a situation where the landlord is not the proper party, you may have instances where the landlord is a business, but they're not in good standing. Or if you have the person for whom is purporting to lease the property is not the true owner, so it may not be the appropriate agent for the property owner to do this lawsuit, maybe one. There are also issues dealing with, do they have a valid lead inspection certificate? Do they have an effective rental property license, if that applies in your jurisdiction? In Baltimore City, that would be the Department of Housing and Community Development who issues those licenses. As well as for tenants who are active duty member of the armed forces, there are special rules in place for them regarding whether or not you may continue on with a suit if a person is an active duty member and they're not present to be in court. And the final two, we'll be talking a little more in depth in the next few slides. If a tenant lives in a premises that has threats to their life, health, and safety, the tenant may raise as an offense for not paying rent. Either they want to pursue rent escrow, they want to claim there's a breach of the warranty of habitability, or a breach of the covenant of quiet enjoyment. All of those will say the base premises is that where I live is inhabitable, and therefore I withheld rent because I gave notice to the landlord. They still haven't done anything about it. Therefore, I don't believe I should have a duty to pay because the landlord hasn't fulfilled their duty to maintain the premises that's fit for human habitation. And lastly, this is relatively new due to our current situation, a tenant may claim that they lost substantial income due to the COVID-19 pandemic and therefore asking the court that they couldn't pay, therefore they should not lose their home. Now, in terms of the COVID-19 defenses, this is relatively new. First, the CARES Act. Congress enacted the CARES Act on March 25th. One of the provisions is that for any property that receives some type of federal financial support, mortgage, or subsidy, a lot of these may be public housing, Section 8 housing, low-income tax credit housing, or even housing that's backed with a Fannie Mae, Freddie Mac mortgage, were all affected by this provision that says that during the period of time, you could not be evicted for non-payment of rent or charge late fees thereof. There's also a provision that says that for those tenants in those properties, the landlord must give you 30-day notice before they even file for a complaint for non-payment of rent. And that the courts, in turn, have imposed a requirement that landlords must file a declaration saying that they are complying with the CARES Act when filing for failure to pay rent cases. And this is for all filers. And that's because sometimes it's difficult to determine whether or not your property is backed by some type of federal financial support. And so it is up to the landlord to declare whether or not those requirements apply to them. And if so, what have they done to prove that they are in compliance or not? Now, for many tenants, they may not see that declaration with the summons that go to court. However, it will be part of the original documentation, and tenants may be able to get a copy of it from the courthouse if they're able to go prior or at least at the day of trial. There's also the governor's executive order. And as the executive order states, until the state of emergency is terminated and the catastrophic health order is rescinded, tenants may raise as a defense in a rent court or failure to pay rent complaint that they suffer a, quote, substantial loss of income as a direct result from COVID-19. Some of the examples of a substantial loss of income may be a result of job loss, a reduction in work hours, your workplace has closed, or that you had to miss work or have suffer a reduction in hours because you must care for a homebound school-aged child. Tenants will have to provide some sort of objective proof. Most common would be a letter from the employer stating that they're suffered job loss or income loss because of COVID-19. That is helpful. But any other documentation you may have to support because of your missed income that's related to COVID-19, you could raise that as a defense in rent court. Now, there are other prohibitions for rent increases and late fees that different jurisdictions in the city have enacted. So, for example, in Baltimore City, in Howard County, as well as the city of Salisbury, they've enacted legislation, different ordinances that states that landlords cannot increase their rent for current tenants or charge late fees during the pandemic. For many of them, you cannot even you can't increase rent or late fees at least 90 days after the end of the pandemic. Some jurisdictions like Montgomery County have limited rent increases to no more than 2.6%. And in Prince George's County, there is a prohibition against the increase of rent for tenants who have a substantial loss of income, and the prohibition of collection of late fees for all tenants. These things, this is a very changing situation. This is why it may be helpful to consult with a lawyer if you're facing a rent court situation, because depending on where you live, you may have different defenses in your rent court situation, because ultimately we want the process to be fair, and to be fair, we need to know what your facts are and what rules apply to where you live. Now, I mentioned earlier that tenants may also raise as a defense that the conditions are so bad that it warranted them not paying rent. One common avenue is rent escrow. Tenants may file this as an independent lawsuit, or they could raise it as a defense in rent court. The common elements is that there are threats in the premises to the tenant's life, health, or safety. The landlord knows of these threats, so somehow, some way, the tenant has communicated, or maybe there's an already order from a public agency like the health department or the housing department about these threats. But either way, the landlord's been put on notice. The landlord's had a chance to make repairs, but hasn't done so. Presumably, we give landlords 30 days to make these repairs for most situations. And lastly, that the tenant prior to the was current in their rent. So either they just began withholding rent, or they're asking permission of the court to withhold rent. For this situation, the tenant is the one who's the plaintiff. They're the one that's bringing this case on against the landlord. And so the tenant has the opportunity, with permission of the court, to deposit their withheld rent into the escrow account, that the court may determine how much rent is paid, if at all, as well as direct the landlord to use that rent money, or on their own expense, to make repairs on the property to take away those threats, or ultimately may ask the court just to terminate the lease. This is an irreparable relationship. The threats here are so bad, it's so inhospitable. Doesn't matter how much money is paid into it, I want to leave. All of those are options, including a few other, about what is possible in a rent escrow proceeding. And again, will be done in district court. Now, the landlord has defenses. One defense, the landlord could say, hey, I never got notice of these threats, and therefore say, hey, I want my 30 days to cure them. Or the tenant calls the threats. The threats are not really threats at all. The tenant denied entry to the premises, so therefore they couldn't do any repairs. Or that the tenant, even if granted a rent escrow account, didn't pay into the escrow as ordered by the court. All those could be grounds to dismiss this action. Now, in terms of process, again, the tenant may file a rent escrow complaint in the district court as an affirmative action, or they may raise it as a defense in a rent case. The court clerk will, take in the information from the tenant, issue summons to the landlord, and instruct the tenant to contact the court inspector. For many jurisdictions, this would be a property maintenance inspector from your local housing department. This inspector, however, has a special duty to the court. They are almost like the eyes and ears of the judge. And so the tenant's supposed to make an appointment with the inspector to check out their premises and see what are the threats. Are they really threats? And they may take photos, they may ask different questions, but they're really the eyes and ears of the court. Since the judge is not going to be going to your premises, it'll be this inspector. Once that inspection is done, all parties will show up to court. It will be, three parties standing on the bar. You will have the tenant, landlord, and the court inspector. And the court inspector will read to the court what they found. And it's up to the court then to determine what are those threats that rises to the level to open a rent escrow account. If the court determines that they are threats, then the court will determine how much is paid into escrow, at what frequency, and when do the parties return to court for an update. At this point, the landlord may also raise their objections. But if the tenant succeeds in getting an escrow account open up, then the tenant is obligated to pay into that escrow account as much as the court determines. And the court will set a new date for when the parties return. Usually ahead of that date, just like before, the court inspector will come out to the property, check it out, see are the threats still there, and if so, the action will continue on, or the inspector may visit the property and see that everything is fixed. At that point, they'll go back to court. The court inspector will provide their assessment, their testimony, and then the judge will determine, what to do, whether to close the account. If the account is determined to be closed, then determine who will get how much money out of the account. And so it is it's a process which is supposed to be remedial in nature. It's supposed to incentivize the landlord to repair the premises so that they can return to getting that rent money from the tenant. And therefore, when it comes to determining how much money to divide among the parties, the statute provides that the court should look into, well, how much money is the value of the premises before the threats? What is the value of the premises when taking the value of the threats remain? And at that determination, divide the money accordingly. And in my experience, I've seen courts divide it 50-50. Sometimes they'll take 1 month to the tenant. Sometimes they'll give all monies to the landlord. It really is up to the judgment of the court and the arguments presented by both parties. All right. So I hear from you. So we just got a raise hand saying that you're unable to hear my audio. So I'll boost the volume here. So hopefully you guys can hear me a little bit better. I can also probably raise my voice. All righty. So moving on to the last cause of action, which is tenant holding over. This has also gained in some popularity because there are landlords, especially in Baltimore City, who do not have a license and therefore are using other tools to terminate leases with tenants and to have them vacate the property. When it comes to tenant holding over, money is not necessarily the central issue here. Tenant holding over is essentially that there's a landlord-tenant relationship where the landlord has given notice to the tenant to vacate the property at the end of their lease term. So for most counties, it is 30 days notice. In Baltimore City, it is 60 days. And at the end of that notice period, the tenant has still refused to leave, therefore holding over. And the landlord is going to the court asking that that person may be removed. Now, the remedies here is to repossess the premises. And that if the tenant was personally served, i.e., the sheriff gives the summons in the hands of the tenant that they want money from, the landlord may also sue for rent due and owing. But in most situations, all the landlord wants is to repossess the premises. So in this situation, the defenses here are narrower versus a rent court situation. The one may be that, again, the landlord's not the proper party to a suit. So if a landlord is an LLC and they forfeited their charter because they haven't made their filings as required by the state, therefore, as a forfeit your charter, you don't have any legal power to do anything. You're not even a being. That could be a defense. But that's in a very narrow situation. You may provide that the landlord didn't provide sufficient notice. So when the law says that you have to provide 30 days or 60 days notice to vacate, the landlord must wait the entirety of that notice period before they actually file a lawsuit. Third, when it comes to tenants who live in government subsidized housing, such as public housing or Section 8 or similar programs, the landlord must have good cause to evict. And then lastly, Another defense could be that the tenant returned premises to the landlord. We don't need to go to court. I've already given it to you. Why are you bringing this action against me? Now, one thing in the law, it does provide that the landlord may accept payment of rent after giving the notice to vacate. However, that is not a waiver of their claim. They still want you gone and they want to collect your rent. And the landlord can argue and have both. Of course, this may be overruled if the parties agree to in writing of a different arrangement. Again, when it comes to tenant holding over, similar process. Once a summons been issued to the court, the parties will come before the judge. The landlord has the burden of proof. They're the one who's the plaintiff. So they have to prove that they gave you notice. They have to prove that they waited that notice period, that you're still there, and therefore an eviction is warranted. But because this is not about money, it's not about did I pay my rent, I have receipts. This is all about I want my property back because I gave you notice that the lease ended. You haven't left, therefore I'm going to court to have you evicted. If the court finds it in favor of the tenant, that ends the action. But if the court finds in favor of the landlord, then the landlord may again apply for a warrant of restitution, wait for the courthouse to actually issue it to the sheriff. And once the sheriff has that warrant, then the landlord may schedule an eviction. And in this situation, there's no requirement of a 2-week notice like in Baltimore City. The landlord doesn't necessarily have to give you notice unless local law provides otherwise. So at that point, the warrant of restitution serves primarily as the notice to the tenant that an eviction may be forthcoming. So lastly, I'm going to share with all of you a checklist regarding what to expect, what to do before trial. And here are some of the major questions here where I'll go a little bit more in depth. When it comes to who owns the property, making sure is the proper party bringing you the suit. There's 2 places you can go to. The State Department of Taxation and Assessment, also known as SDAT. Their website is above, dat.maryland.gov. They have 2 options. You can go to a real property search or go to a business entity search if it's a business for whom you're dealing with to see who actually is the true owner, i.e. the person who has the real party interest in the matter. If you want to dig deeper to see if maybe the CARES Act may apply to them, you can go to the marylandlandrec.net. That's where you can find the actual deeds and mortgages, all the land records in a jurisdiction you can find there. For marylandlandrec.net, you will need to do a registration, but it is free, as well as the opportunity to view and download PDF versions of deeds and assignments. All that is free. If you want to see whether or not a property is current with their lead inspection certificate, the Maryland Department of the Environment has a lead rental registry property search online, which one may use. If you want to find more information about what their certificate actually looks like, what were they required to do, and what level of abatement, you may file a PIA request. That is a public information request. And there are specific rules that would suggest calling the department over what to do in order to get that information. Lastly, when it comes to the apologize. Oh my goodness, no. Lastly, when it comes to the licensing, every jurisdiction is a little different in terms of their licensing laws. In Baltimore City is a little unique in that when it comes to the licensing, it comes from the Department of Housing and Community Development. You may go online to DHCD's website to see whether or not a property is licensed and registered. Also in Baltimore City, if a landlord does not have a license, legally, the landlord cannot charge, collect, retain, or keep rent from you, nor can they even offer a place to rent to you. So effective January 1, 2019, Baltimore City tenants living in an unregistered property do not have to pay rent to their landlord. And upon showing that that landlord's unlicensed, the landlord cannot sue for that rent in rent court. Now, that's for Baltimore City in terms of the rent payment required, but many other jurisdictions do require a license, which a landlord must have just to start a rent court filing. If you believe there are threats in your apartment, by all means, like I said earlier, you have to provide notice to the landlord that there are threats. So one best way, just put it in writing, send it by a certified mail, keep your receipts and show that, hey, I gave notice to the landlord that these are the issues here. So you can show if you're going to raise a defense, I gave them notice and they haven't done anything about it. Another thing, at least in Baltimore City, and there are similar jurisdictions that have this opportunity, you may call 311 and request a property inspection. That'll be helpful because then you have an agent of your locality, someone who will be an expert, presumably, in property maintenance, who can determine what are the threats on the property, give that landlord notice, and administratively, if they fail to cure those threats, may then file an action against the landlord, either fining them or some other similar penalty. And lastly, here's my recommendations. If you're going to court to represent yourself, always remember you have a right to have an attorney with you in rent court. There are many different organizations, such as, I'm at Maryland Legally, but there are other pro bono legal resources for low-income tenants for representation in these matters. And I know in Baltimore City, many other organizations are at the courthouse who are available to provide pro bono advice and some counseling on the day of trial. But I would suggest for everybody who has to go to court, and this is what I do as an attorney, always have a copy of the complaint, bring a copy of your lease, bring any receipts you have. If you're going to raise a COVID-19 loss of income defense, bring proof that you lost income, i.e. getting that documentation from your employer that says that they had to close due to COVID-19 or they had to reduce your hours or you lost employment. If you're going to raise the defense that it's because of the conditions that you didn't pay rent, you want to bring photos and videos and write down what are the conditions that caused you to not pay rent. As for photos, I highly recommend, let's go old school with it, print those photos out. I do not advise regularly for people to hand their cell phones to a judicial officer because once you hand your phone to a judge, they may want to keep it. So I would suggest printing those photos out so they can actually hold it up and see what you've been living through. For those jurisdictions where licensing is a requirement, you may want to get certification from your housing department that says whether or not they have a license. Statewide, all rental properties with limited exception must have a lead paint inspection certificate. You may contact MDE to make sure they are current in that certificate and in compliance with it. And lastly, and sometimes this is an oversight, but this actually really is helpful, bring a pen and paper. You may want to take notes. What's going on, who you've been dealing with, if there's any type of deals that people want to negotiate, or just note who was my judge and what was the order of court. Things happen very quickly in landlord-tenant hearings. And it is easy to forget or be caught up in the moment of the action to lose track of what actually took place. And getting transcripts or audio from a hearing takes days and times. I highly recommend people have their pen and paper so they can take notes about what went on so that if something happened and you want to talk to a lawyer after the fact, you at least got something in writing to jog your memory about what happened. All right. And with that, ladies and gentlemen, is the conclusion of my presentation.
Douglas, thank you so much. That was incredible amount of information and really, really helpful. There have been a lot of questions that I know we have been having, and I imagine some of the participants as well, either for themselves or for clients or for friends or family. So it was really helpful to go over a lot of these details. I will give the opportunity for attendees to ask any kind of question by putting in the chat box. We'll give them just a minute to type. And then I had one question as you were
Yeah.
going information, and this may be a really minute amount of details, so it may not have an answer to it at this point. But it came about from a conversation I was having with someone, and I was like, I don't know how to answer that. So I actually
Hmm.
wrote that to you. But you mentioned the right of redemption. So,
Yes.
if the tenant has gotten behind, but now they have, been able to catch up, and you say they can keep possession of the property by paying the judgment amount by cash, certified check, or money order. And the question that someone posed to me, which I referred to you, is particularly right now, this person didn't want to go out to a store to get any of those methods, whether it's a financial institution or a local store to get a certified check or something, and they
Hmm.
wanted to do Venmo. Do you
Hmm.
know if that would be an acceptable form of payment? Does that
Yeah,
matter?
there's nothing stopping. Well, one thing to keep in mind, many of these statutes were written before the age of the internet. And so that's why you don't have electronic transfer of funds as an option. However, if the parties agree to accept payment electronically, then I would I don't think that's necessarily a problem. You just gotta make sure you have a receipt for your transactions. And we see this often when it comes to cash. By law, you're supposed to get a receipt anytime you do a transaction, but very commonly people have trust with their landlord, especially for a lot of small landlords, there's that relationship. And so when things are good, people don't think about keeping a paper trail over everything because they think if it's good now, it may be good later. However, when things happen, that's when there may be questions about, well, what paper do I have to document that actually paid my rent on time? So I would suggest if you're going to use Venmo or Cash App, what have you, get a receipt. If you're in a situation where a receipt is not available, make your own receipt and have the landlord send it file. Or if they're going to take it electronically, have them send you an email or a text that says, "Hey, I got your money." You need to have some sort of a
Mm.
paper trail, whether that's electronically or a hard copy, that you made this transaction.
Douglas, that is so important. As a former investigator, my mantra was good paper makes good friends. So
Mm-hmm.
critical. You're absolutely right to have that documentation. And you're making me think now, even before sending a Venmo payment, there needs to be some kind of something in writing, because once you send it in Venmo, it's gone. You
Yep.
can't get something at that point. So that's a really good thing to add. There are a couple of things in the chat box just to cover if we can.
Yes.
One of them, is it all right for us to send out the slides? We are recording this, so the recording will be on Cash Academy, but is it all right with you to send the slides out to participants?
Um, by all means, I mean, I can give you a PDF copy if you wish to distribute it to whomever. I can give you a PDF version of it. So that's not a problem.
Okay, and so to participants, if you registered on Cash Academy, I will have your email that way and can send it out. So if you have registered that way versus just clicking on the link, I will be able to get it to you. If you just clicked on the link and didn't register, you can email me at sue@cashmd.org and let me know that way, and we'll get the PDF version of these out to everybody. So the last question is, do you know of any resources clients can tap into to prevent an eviction? I know about eviction prevention assistance,
Mhm.
but are there any others?
So it depends upon your jurisdiction. That's how a lot of these COVID-19 rental assistance programs have been distributed from the federal level to the state level and then to the different local jurisdictions, either at the city or county level. And unfortunately, at least in July, there was a brief window of opportunity where teams were able to apply for it. And now for many places, that window has closed. So at this point in time, it looks at if one was in Baltimore City, one opportunity is calling 211 to see what other sources are available, either from the local or state government for it. Most common has been eviction prevention, which is, at least in Baltimore City, is in the courthouse. It's also run by Department of Social Services. And then the Baltimore City Mayor's Office also provide funding. When it comes to the counties, again, it is every county is a little different in terms of how they handle that rental assistance. I would suggest if one wants to, you may call the legal aid office that's nearest to you to see if their social workers and attorneys may have better resources as in your locality. And if you are in a place that uses 211 as a direct source for citizen services, then I would suggest calling 211, at least in Baltimore City. That's one available avenue to see what kind of financial sources are available. And last, I want to point out, and this is back to my last point about how local jurisdictions had different rental protections. There are some localities that are now enacting rules requiring landlords to enter the payment plans with their tenants. So if that rule applies to where you live, then that may be another avenue to negotiate with your landlord a way in which you can make some sort of payment. And as a condition for you making those payments, the landlord would withhold, filing a rent court action against you. And again, have it in writing.
Mhm. Very, very important. And you're absolutely right. What we're seeing as well is that it really varies depending on the county that the person lives in. And Angela Fraser had been on this. There had been some assistance through DHCD and some state agencies. So it's imperative for us,
Mm-hmm.
to, as we're talking with people, that it takes some work, right, to find all the different assistance that's out there. But it's a bit of a hodgepodge, and you have to look kind of hard to see, are there state resources? Are there local county government ones? Are there faith-based, resources,
Mm-hmm.
community programs? So it does take a little bit of detective work, sort of, to kind of figure out what are the various resources. And if anyone on the call knows of some in their particular area, please send them to me, because on Cash Academy, we are trying to curate all of the information that is of assistance to people, particularly in regards to this pandemic that we're in right now. So if there are rental assistance programs, I know we have some on there for Anne Arundel County and Montgomery County and Frederick, but if there are others out there, please let us know, because we really want to put everything in one place to try and make it a little bit easier for people
Mm-hmm.
to find the resources they need. So please let us know if you know of any additional resources that are not on Cash Academy at this time. All right, are there any other questions from our attendees? All right, well, seeing that there aren't any coming in, again, Douglas, thank you so much for taking time today to provide this information to us. We would certainly like to have you do a repeat webinar for us coming up in the future. Again, this will be recorded and put on Cash Academy. I will send the PowerPoint slides out to those that registered on Cash Academy. And thanks to everyone who participated and attended and taking your time today to learn this information. We really appreciate your being here and spreading the word out to those that you either work with or friends and family. So please, everyone, stay safe and have a good rest of your day.
Thank you very much, and please take care.
Thank you. Bye, everyone.